Thank you very much for joining us this morning. Welcome to today's webinar on protecting our youth, sponsored by the Orthodox Christian Attorney Network. We are so glad to have you join us on this very important discussion. For those of you who are new to OCAN, let me introduce myself and my co-speaker. My name is Ken Liu, and I am a member of St. Mary's Romanian Orthodox Church in Falls Church, Virginia, part of the OCA. I'm the executive director of the Orthodox Christian Attorney Network, as well as general counsel and senior advisor of the Orthodox Youth and Young Adult Ministries. OCAN and OYM are actually collaborating in creating a model youth protection policy, which I'll discuss a little bit later. If you're not familiar with OCAN, we have been an informal group of attorneys for about 7 years, but just this spring, we incorporated and formed a formal nonprofit corporation. And I'm excited to say that just last week, we received our official 501c3 approval. So we're very excited. The mission of OCAN is to inspire Orthodox attorneys to integrate our faith into the practice of law, to serve and help strengthen the Orthodox Church, and to impact the world for Christ. And this webinar, as well as the youth protection policy that we're creating, are examples of how we're serving the church. And so we're really grateful that you're on here. And I'm also grateful to have us joined today by Alex Rushing. She is a member of OCAN and a partner in the law firm of Hush Blackwell, and she practices in the field of education law. So she has a lot of experience representing schools and other clients on these types of protection policies. Alex will give us a general overview of youth protection policies and legal issues surrounding them, and then I'll get into more specifics as these issues apply to Orthodox parishes. Without further ado, I'll turn this over to Alex.
Thank you so much, Ken, and it's great to be with all of you. As Ken mentioned, my name is Alex Rushing. I'm based in our St. Louis office, but I practice all across the country. I'm a partner at Hush Blackwell and actually was a public school teacher before I became an attorney. So I used to handle these issues from abuse and neglect related to the mandatory reporter side of things. Now I advise on it, which is just a different frame of reference. And so I'm very excited to bring this to OCAN. I've worked with a lot of religious schools and other religious organizations, but never an Orthodox Christian organization. And so I'm hopeful that this inspires many of you to take this back to your churches, your schools, and your dioceses to hopefully implement a lot of the strategies that Ken and I strategized over in order to develop this session. So let's dive in right into the agenda and talk about what we plan on covering today. It is absolutely a packed agenda. So if Ken, you don't mind moving a couple more slides, we're going to talk a little bit about what the definition is of a minor. What do we mean exactly by that? We're going to talk about youth, minor, things like that, how it's different across different states. Then we'll talk about liability and risk associated with programs involving minors, how they're different than those programs that we offer for adults, young adults, seniors, things like that. And then some practical tips and tricks related to mitigating risk that hopefully you have some great takeaways to take back to your churches, parishes, dioceses, what have you.
And
So
if
let's
you
dive.
do have questions, feel free to put it in the chat room, but because we do have a lot to cover, we may wait until the end. We will reserve some time for questions and discussion as well.
Yes, thank you, Ken. So who is a minor? Let's dive into that. It really depends on the state in which you're physically located. In most states, it's considered under the age of 18. That's true in Missouri and Kansas, Illinois, several others. Some states differentiate between a child, between a youth and a juvenile. And then other states actually have a legal age over 18 that they consider the person to be a minor or youth or child. It sort of just depends on what your state law is. So for purposes of our discussion, we're going to use that under 18 rule of thumb, but we want to be mindful that this really does depend on where you're physically located, where the church is physically located, where the alleged potential abuse is, things like that. And it's really important as it relates to issues regarding consent, which we'll dive into in our case studies portion of this session. So let's go into the practical implications. What are the practical implications of having minors in your various programs? So we have a list here on your screen, and we'll talk about each of these, but these aren't the only ones. There's all sorts of other areas to think about. This is sort of just broad strokes of what Ken and I perused and thought through when we were thinking about our various practices advising colleges, universities, schools, and religious organizations regarding this topic. So we would be remiss if we didn't talk about mandatory reporting that intersects in a lot of what we talk about in this space. All states require some form of mandatory reporting. Again, it's different in every jurisdiction. In most states, persons who work with minors are required to report known or suspected abuse, neglect, or other inappropriate interactions. When I was a public school teacher, I was considered a mandatory reporter. And it's interesting to be on that end of things, to be someone who is trained on that topic. I think I take so many lessons from having been in that role now to my practice as a partner at a law firm of it's great to learn the law, but tell me the practical side. I'm the one making the phone call to DCFS, right? What do I have to do? Who do I tell at my school? Why am I doing it? What are the implications for my student? All those sorts of things. And those might be the questions that you're thinking about if you're a member of the clergy or if you're running a summer camp for your diocese. Those are all the things to think about as you're developing your own policies, procedures, and then related training. So when we talk about youth protection, protecting minors, things like that, when we think of it, this is sort of the initial mapping. When I talk with most of my clients, I'll do an item called a minors audit. And when they sort of think through from a religious organization standpoint, here are some of the things that come to mind most frequently, whether it's athletic events, summer programs, structured programs throughout the year. And then after we review, upon that further review, then when we actually dive into it, it looks a lot different. So let's advance a couple slides and take a look at what we actually see in practice. There's all sorts of areas that cover our youth and cover minors that potentially may implicate not only mandatory reporting obligations, not only background checks, but all the risks associated with and all the benefits associated with encompassing our minors into various programs that we offer as a religious organization. So let's figure out that that's all the risk associated with it, but how do we actually tackle this issue? So one of the best strategies is to establish a working committee or a working group to actually dive into this on a regular and systematic basis. Various different types of stakeholders all across your church, your parish, your diocese, whoever it is that you're helping implement. This is going to be really important. That working committee is sort of the heartbeat of figuring this out and how it relates to your specific community because it's so different for my churches that are located in a very rural part of Missouri compared to my churches that are located in an inner city urban area in California, right? Those are completely different. So making sure you have specific stakeholders as part of that working committee is going to be really important. And then identifying what key areas of risk might impact your church, parish, diocese the most, right? You may not offer summer camps, so that might not be number one on your list. Most of my clients do offer summer camps, so it is number one on their list, and that's okay. So thinking that through what that looks like for your specific organization that you're either advising or that you're part of this working committee is going to be really important. It could be Sunday school, it could be overnight programs, summer camps, as I mentioned, youth programs, things like that. It's going to be different for every single organization. So prioritizing it according to what areas of risk are most vital for you is going to be really critical. And then developing a strategy document with deadlines and deliverables. Ken's going to really talk from a practical standpoint about that youth protection policy and related procedures. I'll dive into some of the additional documents to consider related to some of the areas that I highlighted in those identifying key risk areas features, like the overnight, the travel, things like that. And you'll want to think that through as that working committee, especially if you're the one either leading it or participating in that working committee. Okay, so we've talked about what a minor is. We've talked about some of the risks associated with it, how to think it through as a parishioner, as an active member of your community. Now, what can go wrong, right? We are all attorneys. And so unfortunately, we sort of live in this space of that's great to tell us what the risk might be, what's actually happening in the court system, what's happening on the ground, so to speak. So let's dive into that. Here's our first example. This situation involves a former student in an Orthodox Jewish high school. That student brought an action against the school and the rabbi who served as the school's chief administrative officer, alleging that the rabbi sexually molested him while he was a student and asserting claims against the school for negligence and negligent infliction of emotional distress, claims against the rabbi for sexual assault and battery, and claims against both defendants for recklessness and intentional infliction of emotional distress. Let's dive to the next slide. The Court of Appeals denied the church and camp's motion for summary judgment, finding the release forms that were used, they actually had release forms that were used in this case, that those were considered overly broad and buried in provisions unrelated to pre-injury releases. The court noted that although releases for exemption from future liability for negligence are not invalid per se, such contracts are disfavored and are strictly construed against the parties relying upon them. Because the law disfavors such contractual provisions, the wording of the release must be so clear and understandable that an ordinarily prudent and knowledgeable party to it will know what he or she is contracting away. It must be unmistakable. In this case, I don't want to bury the lead. The verdict ended up being appealed, and the Court of Appeals upheld that decision of a $21.7 million verdict against a teacher and the private Jewish school for the teacher's sexual molestation of the student, and that this was not considered excessive and would not be overturned. We have the citation on the screen for those of you who are legal nerds like me and want to actually read the underlying case and take a look at it. Let's dive into the next one, talking about a child guest. Here, this involved a school asking a community college to serve as a job training site for a student with special needs. The community college agreed to allow 18 to 21-year-olds with developmental disabilities to participate. The student in this particular situation had behavioral problems, including stealing, sexual aggression, and obsession with small children. The mental health clinician advised that the student should not have any access to young children or vulnerable peers while participating in this community college-sponsored program for children with developmental disabilities. The student was first assigned to the college's custodial staff without incident. About 2 months later, the student was reassigned to the college's cafeteria. The head cook was directly responsible for overseeing all kitchen operations, including of the student. And let's dive into the next couple slides. Another student brought her 5-year-old daughter to campus, and after attending class, the two of them, the other student and her 5-year-old, sat in the cafeteria while the mother worked on a project, that other student, also between the ages of 18 and 21. The girl went to the bathroom unaccompanied, the 5-year-old. The student in that situation who was participating in the cafeteria program followed the 5-year-old into the restroom and began to strangle her. A fellow student happened to be in and entered the restroom and rescued the girl. The story ends in the girl not sustaining any life-threatening injuries. On the following slide, you'll see that the mother did sue the student, the school district, and the college. The student defaulted, and the school ended up settling the case for $400,000. The case proceeded to trial against the college on claims of negligent supervision. Ken and I want this session to be as interactive as possible, so we're going to throw up a poll question and ask all of you, what do you think the value of this case was worth as it relates to that community college? Do you think it was worth less than $100,000, $100,000 to $249,999, $250,000 to just under $500,000, or you think this is $500,000 or more? Those of you who are in that sort of $500,000 or more category, you are in the majority. This was a $1.35 million verdict, and that ended up being the result from that particular case. So 1.35, we've already seen one at the 21.7, now we're at 1.35. Let's talk about our next example involving summer camp. This is the most common situation that my religious organizations have questions about, especially those that do not have schools affiliated with them. Those of my clients that have schools, there's so many more complicated issues, and that's sort of why we led with those first two examples. But for those of you who are operating or working at a specific church or advising your parish or diocese that doesn't have a school affiliated with it, summer camps or overnight trips are usually the most common questions that we get related to protecting minors. So let's go into this case example. This was a 12-year-old enrolled in summer camp. The summer camp involved a variety of activities and overnight stay. It was an advertised summer camp on the main website of the particular organization. As part of that summer camp, a 17-year-old camp counselor, who was also a minor in that particular state, attempted to choke a 12-year-old camper and threatened that camper with a knife. The parents of the 12-year-old sued for negligence because, one, the counselor was underage, two, the organization failed to perform background checks of their counselors and staff, and three, the camp overlooked, quote, warning signs that they knew about, that sort of foreseeability piece. So Ken, let's throw up our next poll question. What was the value of this particular case? Was it less than 100,000, between 100,000 and 249,999, between 250,000 and just under 500,000, or 500,000 or more? So in this example, this one was actually worth 400,000. So the correct answer actually is C in this example. So maybe we tricked you on our prior ones of overinflating. So there's all sorts of different ways that some of these cases get resolved. And so we wanted to make sure to show some of that diversity. So now that we've talked about the case study side of things, let's talk about how we actually go about evaluating programs involving minors. So things to think about. Should youth programs be subject to church or diocese approval? What's the cost benefit? What are the risks associated with it with regard to the particular programs we offer? And then what are the clear categories of activities that the church, diocese, school, whatever it is that you all are advising on, could treat similarly? How do we sort of bucket things in priority order, in order of what's most important and where the most risk is for our organization? Okay, let's talk about managing that risk. So taking an inventory of what actual programs you have, developing those policies and procedures. Ken is going to show you a great model policy and making sure that you revise those to be as particularized to your community as possible. Making sure you develop materials about the programs to share with participants and parents. I always tell my clients that you can have the best policies in place, but if nobody knows about them and nobody follows them, it's as if you don't have them in place, right? And all of you know that as attorneys, but it's really important, especially in this space, because we're not just talking about adults reviewing these policies. Sometimes children are the ones that are reviewing it themselves, right? We might have a 16-year-old who wants to report it themselves. They need to be able to understand these policies. And thankfully, with things like AI, I now take my minors policy. We have a proprietary software at Hush Blackwell where I will throw it into our AI platform and say, make this as easily understandable for a 15-year-old youth to understand this policy. And it will revise it to make sure that I'm not having that legalese that maybe I would if I was targeting it at more adults. So really thinking through who your audience is for those policies is going to be really important. Professional development and training is critical. Again, you can have great policies in place, but if you're not training anyone on how to use them, it's as if you don't have them in place. So making sure that you have that. And then as it relates to sort of the risk management and mitigating the risk, a lot of you who have either molestation insurance, church insurance, whatever your underlying insurance is in this space that may implicate minors or youth, depending on your jurisdiction, will usually require some type of policy or procedure that's in place regarding this, but also to train your folks on it. And your insurance company, to the extent it gets triggered, hopefully it never does, right? Either via a lawsuit or a complaint of some kind or an internal investigation, you want to make sure that you have not only just developed the policies, but you've also trained on it. It's going to be that sort of two-parter is typically what I see in most insurance. Okay, so we're going to dive a little bit deeper just for a few minutes regarding certain areas, regarding supervision, regarding parent protection, things like that. So one of the things to think about is background check procedures and if that's appropriate, whether it's required in your jurisdiction or not, whether it's something that you want to implement, even if it's not required to implement as a best practice, things like that, depending on the specific position, depending on the specific role for the individuals who are interacting with your minors. The next slide, we talk a little bit about travel with minors. This is an area that we see, unfortunately, something in hindsight people think about, right? They don't realize all the risks associated with transporting minors. Sometimes you'll think about the overnight stays, maybe that's the most obvious, but actually traveling, whether it's in a bus or a car or via plane, even if it's a very short distance, right? It can have all sorts of risks associated with it. And so making sure that you have a trip plan to assess that risk and what the proper supervision and any required authorizations that you need are going to be really important. And we'd be remiss if we didn't mention it here. The next piece is an internet use policy. When I attended Gračanica church camp, this was not at all something they thought about, right? We didn't have the internet back then. That's how old I am. And so this is something that is not necessarily new, but is something new that folks are considering. I think a lot of times when we think about summer camps or youth programs, we want our children to be as unplugged as possible, right? Whether they're, learning more about their faith or they're learning more about their culture, whatever it is that they're participating in. But for better or worse, technology is here to stay. And we are seeing more and more children at younger and younger ages having cell phones. And those cell phones have the internet on them. And so having an internet use policy is going to be really important, and making sure that you're enforcing it is going to be equally important. The next piece is pick up and drop off of minors, and it really relates in part to the next slide that talks about custody issues and things like that. You don't know how many issues and phone calls that I get involving parents who are in a custody dispute, or this child cannot pick up their younger sibling and things like that. So thinking through those sort of age appropriate and program appropriate questions are going to be really critical for all of you. The other piece to think about is ratios. This is a question I get a lot about, and a lot of times most jurisdictions don't have a requirement related to what these sorts of ratios are for youth programs, for summer camps, for any sort of thing that involves a religious organization. They usually do for a public entity, not so much for a private one. And so that's where we have to think through, sort of from a best practices standpoint, what works best, and following things like the American Camp Association guidelines and whether that works for your organization or not. And that's where that sort of benchmarking with your council, or with the help of you as their council, will really help to figure out what works best for that particular program and that particular program's needs. We talked on the next slide already a little bit about the parent guardian observation and visitation policy. It's something to think about in tandem with what Ken is going to talk about at the end from a youth protection standpoint. And then any custody or child custody considerations, to the extent it's ongoing or there's currently a custody order in place, you want to be really mindful of that and respecting it for all the parties involved, right? And keeping in mind, our children being the number one focus and number one. The next piece is medical information. This is one of the most challenging areas for my clients to navigate. And so having the proper authorization forms, having proper policies and procedures related to allergies and EpiPens and administering medication, whether prescription or not, is going to be really critical. And thinking it through before an incident happens, right? Figuring out what your students who are participating in that youth program, what allergies or immunizations or things like that they're required to have, is going to be really important before you have an issue. So that's just sort of a reminder related to that. I know I'm almost at time, and the final slide, sliding into my final section, is related to acknowledgments and waivers. This is really, really important. Although you saw in that one example from Kentucky related to an Orthodox Jewish program, that particular example used a waiver and had some type of acknowledgement in it. The underlying allegations of child molestation are going to be the most common in which a waiver is not upheld or not permitted, right? Doesn't mean you shouldn't have a waiver, right? Some of my clients read that case and say, well, if I'm going to get a $21.7 million verdict, why do I even have these waivers in place? And in a lot of situations, there's so many other types of conduct that we want to account for from a negligence standpoint. So thinking through what your specific state requires, whether you have to bold text, whether it has to require both parent signatures or only one, whether the student should also be a party, the minor, or not, how you should maybe have acknowledgments along each of the subsections because it involves a minor child. All of those considerations are very state specific and community specific. And so thinking that through when you're developing your acknowledgments and waivers is going to be really important. Okay, I've been talking for a long time. I know we're saving time at the end for questions. I'm going to turn it over to Ken to dive a little bit deeper into sort of how this relates to our Orthodox faith as Orthodox Christians. Thank you so much, Ken, for having me.
Thank you, Alex. That was very helpful. So we're going to get a little bit into the Orthodox context here. And first of all, why should Orthodox churches care about youth protection? Well, abuse of youth is really one of the worst evils that can be inflicted upon youth. It robs them of their innocence, it causes a lifetime of trauma, and it often turns youth away from the faith. And as you can see here, John Chrysostom very much cares about our youth. For the sake of time, I won't read that. But what we want to remember is that we as leaders and adults in a parish, we have not only an ethical, but also a legal obligation to ensure the safety of our youth. And child sexual abuse is both an egregious sin, but also a serious crime, and we need to treat it as such. Now, although the love for our children itself should be sufficient to compel us to take steps to protect them, there are many worldly reasons for us to care about the safety of our children as well. For one thing, child sexual abuse is the number one reason that churches are sued. More than property disputes, money disputes, sadly, it is child sexual abuse. And churches whose negligence results in molestation can be penalized with civil damages. Some cases can result in legal fees of well over $1 million, as you saw in Alex's examples. And so it really is incumbent upon us to take these issues seriously. Now, past few decades, we've heard so much about sexual abuse in the Catholic Church, in Boy Scouts, in girls' gymnastics, and we haven't heard too much in the Orthodox Church, thank God. But that the downside of that is that I think it has lulled us into a sense of complacency in thinking that it doesn't affect us, and that is far from the truth. So I debated whether to give some real examples in the Orthodox Church, and I don't want to do it because I'm trying to scandalize anyone or point to any specific jurisdictions, but I felt it was important for us to know that there are really serious cases in the Orthodox Church. One priest in the GOA parish in Chicago in 2007 were sued by two men who were sexually abused while they're altar boys decades earlier. And the church leadership allegedly knew about the pedophilia and covered it up. That case was settled, so we don't know the details of it. There was a similar case in the Antiochian Church in California. A priest sexually abused 6 youth in the 1970s, and it was brought to light 3 decades later, and the priest pleaded guilty to 19 felony child sexual assault charges. A more recent case is that in the Serbian diocese, there was a sexual abuse committed by a monk. And that case also settled for about $250,000. And in that one, even though the settlement turned out to be lower than people expected, which was obviously good for the church, but the legal fees amounted to over $1.5 million. So that is all just to say that we in the Orthodox Church need to take this seriously, not just because we care about the kids, but it really does affect us legally as well. A little bit about who are perpetrators. So a lot of people are also lulled into complacency because they think that sexual perpetrators are these dark, sinister people, who come and snatch our kids away from the street, and we would never let that happen. But in actuality, the majority of people who commit sexual abuse are people known to the child, whether it be an acquaintance, trusted family and friends, and people in position of authority. And there really is no way to predict and know for sure who can potentially be a perpetrator, because perpetrators are often very kind, very friendly, even very devout outwardly. And in fact, that's how they get access to these kids. It's because they build a sense of trust and love with the church, with the families, and nobody suspects that they are perpetrators. And so the way we can manage the risk is by having a good policy and procedure to prevent these issues. Some people might be wondering, well, these are obviously crimes committed by individual people and not within the scope of the clergy's employment, or it's not within the ministry of the church. So what are the grounds that churches can be held liable? Well, 3 main legal bases. One is negligent hiring, where a parish failed to act with due care in the selection of workers, either volunteer or paid. Negligent supervision, even if they did proper vetting and hiring, they did not properly supervise the youth workers or employees. And then finally, negligent retention. Even when church leadership knows that there are some factors or evidence that there might be something amiss, they fail to take proper actions. And so these are the primary grounds by which churches can be sued and held liable. And so I'm proud that the Orthodox Christian Attorney Network and the Orthodox Youth and Young Adult Ministries are working together to create a model policy for use by all of the jurisdictions that don't currently have one, hopefully. Currently, the GOA and the OCA have formal policies. The other jurisdictions do not, but I'm very happy to say that the Antiochian Archdiocese recently have been working with us and have begun to adopt parts of the policy, and they're doing it in stages, but it's wonderful to know that they are taking steps now to implement some of the things that Alex talked about and that I'll share in the next few slides. So to go over what's in a youth protection policy, these are the key issues that we need to have in it. Well, first of all, we need to actually adopt, implement, and enforce a protection policy. And as I mentioned, we need to properly vet youth workers. So background check is the first step. We want to check before anyone gets involved in youth at our parishes to know whether they have any criminal records. And so the policy first level of defense is just to check, have they committed abuses in the past? Before hiring them or letting them serve with youth, should check references. And for volunteers, we recommend that the volunteer actually be a member of the parish for at least 6 months and maybe even over a year so that you can get to know the person before they serve. As I said, so many of these perpetrators are extremely friendly, they get really involved, and it's hard to distinguish between improper motives and genuine love for the kids. It's this sad part of the culture that we live in that, we have to worry about these things. Sorry, slide was out of order, but we recommend that every parish appoint a youth protection coordinator, someone who can be on point to take care of all these policies and make sure that it is implemented and enforced. One of the first things that you'll want to do is to determine who are what we call youth workers. And that's important because you want to know who do we need to do background checks on, who needs to comply with all of the procedures and policies that will be in the protection policy. So we recommend this definition: all staff and volunteers who are involved with youth in any parish ministry on more than an incidental basis. Is very broad and intentionally so, because we want as many adults who could potentially have interaction with youth to be included in this definition. And that includes all the obvious ones: youth program leaders, as well as their helpers, Sunday school teachers, youth advisors and mentors. If you have a nursery program, definitely those who volunteer in the nursery, as well as non-ministry activities that your church might be hosting: sports teams, culture, language programs. We want to do background checks, as I mentioned, but background checks is not a silver bullet that only catches people who are repeat offenders, but there's always going to be new people. And so you need to develop a system by which you are constantly vigilant. One of those is to have a youth protection training program. If you sign up with a background check provider, usually they will have a pretty robust program that comes with it. And so oftentimes parishes will just go with the background provider, their own training program. A code of conduct. The policy that we're creating has a suggested list of appropriate and inappropriate behaviors. These are some obvious ones here: no sexual contact, no physical contact that the youth finds unwelcome. And this third one might be a little bit more controversial, no tickling, no massaging. I know there's a lot of especially youth, older youth, who like to work, to just have a little fun with younger kids. And most of the time when you're wrestling and tickling and just messing around, it's perfectly innocent. But unfortunately, those are also often the first telltale signs of someone going deeper into inappropriate relationships with kids. So, there's a lot of things that you'll see in the policies that might sound like, oh, we're being killjoys. We're trying to dampen enthusiasm among our youth ministries. But there needs to be a balance. Obviously, you want to have, friendly youth workers, friendly people who really engage with kids, but at the same time, you need to put up guardrails. You need to be aware. Some other best practices, just as a few examples. This is one of the key ones, that youth workers should generally not be alone with any youth. And that means, as a policy, every program, no matter how formal or informal, needs to have a minimum of 2 adults there. To youth workers who have been vetted, who do know the policies, and who have agreed to abide by these best practices. If in the instance where you might not be able to have 2 adults, like I know this is often a struggle with smaller parishes, at least you should have a situation where the adult is together with multiple youth. So that significantly decreases the opportunities for the adult to take advantage of any youth. Facilities, this is a very important one. Make sure that all your doors in your rooms where youth programs are held have windows, or if not, then the door should always be left open so that you can have other adults walking by and peeking in and just checking on things. And then when there's no programs going on, these doors should be locked so that during the downtimes, which is the times when unfortunately a lot of inappropriate behavior occurs in between formal programs, or during coffee hour when everybody is in the fellowship hall and there's kids wandering around alone, perpetrators will take advantage of that and go into unlocked doors. One adult youth interactions, and this includes confessions. Now, I know this is a tricky issue because obviously you want a lot of parishes want privacy and quietness in confessions, as well as counseling and mentoring sessions, but there needs to be some guardrails to protect youth. And so these are some examples. Make sure there's another adult that knows about, whatever is going on, counseling or confessions. Do it at a time when there are going to be other adults nearby. And then the priest needs to avoid physical affection that can be misinterpreted. That goes for any adults, actually, in any kind of a situation. Alex talked about internet communications. One way that youth workers progress in the relationship with the kids that they're grooming is through texting and electronic communications. It starts out official, starts to get, very friendly, and then it gets deeper and deeper until they build this relationship of trust. And so one thing that we recommend is that there is no one-on-one electronic communications between youth workers and youth. Ideally, they're either connecting, including their kids' parents or other parish leaders, or the electronic communications are to an entire group, the entire youth group, and never one-on-one, where they can say, oh, hey, can you text me a photo of yourself? Or, hey, you want to get together after youth group, on Saturday and we can hang out or something. There's electronic programs now where the staff, other people can see what all the youth workers are texting to the youth group, and that's something you might want to consider using. Mandatory reporting, very important issues. In all states, certain people are designated as mandatory reporters, which means that they are obligated by law to report to legal authorities if there is any reasonable suspicion of abuse. And in 29 states, clergy are designated as mandatory reporters. And because it's a state by state, this is where lawyers can be real helpful in finding out what your state's laws say about who are mandatory reporters and what needs to be reported, who they need to be reported to. A mandatory reporter who fails to report any suspected abuse is committing a crime, and they can be held liable both criminally as well as civilly. And there's a trend that even in some states, they're making all adults into mandated reporters. So here are two websites you can go to find out more about who are mandated reporters and what the obligations are. What needs to be reported? Any kind of suspected abuse, any kind of evidence, including witnessing some kind of inappropriate behavior, a youth self-disclosure, or physical or behavioral science. This is an issue that is very important for priests to know about, the clergy penitent privilege. We hold it as sacrosanct that information revealed in confessions should be held confidential. Unfortunately, there's more and more states who are turning against that. Some states still exempt clergy from using information that is found in a confession, so that if someone does reveal a past act of abuse, the clergy does not have to report it under law. But other states are really going in the opposite direction, where they're kind of whittling it down. And so you really need to pay attention in your state. What are the laws about information that is revealed in confessions? We hope to have a webinar specifically on this topic in the near future, because we know that this is really important. One of our members, Deacon Justin Bozel, is actually giving a talk on this at the Orthodox Canon Law Society conference in Boston next month. If you are interested in that, you can come and listen to that. Statute of limitations. All 50 states have eliminated statute of limitations for child abuse criminal issues. And more states are eliminating it for civil claims as well. And so that's how we can have kids who were abused when they were children, as altar boys or whatever, 30 years down the line, bringing lawsuits. And so you might not know of any cases in your parish, but if it happened, 20 years ago, you could still potentially be sued for it. So kind of want to bring the formal presentation to a close, and then we'll take questions, how lawyers can help. First thing I want to say is that in adopting these policies, in enforcing them and training people about them, the goal is not to create a sense of fear. We don't want a culture of distrust and skepticism of everyone. That's not what it's about. We want people to be aware and take it seriously, and not just think, oh, that's a Catholic problem, or that's never going to happen in our parish. We know everyone in our parish. But the goal is to develop a culture of awareness of the fact that these things can happen without, our, even if we know everyone in the parish and everyone seems perfectly friendly and devout, these things can happen anywhere. And so if we can just have these guardrails put in place and have proper policies and procedures, not only will it help to prevent these issues, but a lot of people are also concerned about, well, what about the liability? The more that you are following proper policies and procedures, the more likely you will be able to avoid liability. That shouldn't be the main reason why we implement these, but it's something that is obviously important. So how can lawyers help? Lawyers by nature are more attuned to these kinds of issues and the importance of following policies and procedures. So if you are in a jurisdiction that has a policy or is about to adopt a policy, please get to know those policies and help your parish council, help your clergy, help everyone in the parish to take them seriously, to abide by the policies, and help to develop this culture that I'm talking about, culture of awareness. For those of you who are in jurisdictions that don't have it yet, I would love to talk with you about how we might be able to help your diocese and your jurisdictions to adopt a policy. Um, and as lawyers, you can help do some of the research that I talked about in getting to know the laws of your state, especially as they apply to mandated reporters, reporting obligations to legal authorities, confidentiality issues. And, and for those of you who are not lawyers, I hope this was a wake-up call for you too. And you can help do the same things. You don't have to be a lawyer to help the parish develop this culture of awareness, to develop a sense that, hey, this is something that we do need to take seriously.
So Ken, I've been answering some of the questions in the chat directly. I don't know if you want
Okay.
to read those answers. I wanted to make sure just in case we ran over time that everyone got their questions
Ah,
answered.
thank you. You want to call out whatever you think might be useful to talk about?
Yeah, sure. And I'll offer one specific one that came through a direct message to me because I think it's really important, this concept of mandatory reporting. I think it's one that's really complicated, and it's extremely important to have a great policy and to train on it, like we've said over and over again, but to also talk about what in practicality as a mandatory reporter, whether that's as clergy or that's because you are a youth director as part of a program or because you've instituted through policy that all your counselors are mandatory reporters or anyone interacting with minors are mandatory reporters. What I like to do in my trainings that I do on this topic for my clients is to actually walk through a situation and what you do about it, right? The actual number that you call in that specific state, the actual person that you speak to, how you do that type of reporting, what information you need to share, and then who internally you need to share that information with. I think sometimes in situations, and I know I experienced it as a teacher with my fellow colleagues, they would tell me, a fellow teacher would say, "Do you think this is a mandatory report?" And we would say, "Yeah, I think it probably is." And I would assume that they would report it, but I wouldn't follow up. I would have no idea, right? It would have been actually my duty to also report it. Now that I know that information, I shouldn't just trust the fact that that other mandatory reporter is now sharing that information. So I hope that answers the direct message question. That the person shared that it did, but I thought it was important enough that I would share. It's always better, at least in my experience and how I advise my clients, to over report, let the governmental entities investigate it and make a determination one way or the other. And it may be unfounded, right? There's plenty of circumstances, especially as it relates to someone in that sort of borderline. They transition from a child to, or a minor to, an adult. We have a lot of historical misconduct issues that we investigate. Typically, governmental entities will actually not investigate a lot of those if the alleged victim is over 18 at that point. That typically is outside of most of their jurisdiction. They want to get at the abuse of an ongoing minor. So thinking that through too, that sort of historical misconduct, because I know that came up throughout our session, is also going to be important. So that was my piece, Ken, that I shared. All the others have been in the public chat.
Great, thank you. I see a question just came in from Father Chris about summer camp staff wanting to communicate with, I assume it means with kids after the camp. That is a really tricky one. Definitely, they should not be communicating with kids. Well, I was going to say during camp, obviously, they won't need to communicate electronically. After camp is over is a lot trickier because at that point, they are no longer in a formal programmatic relationship. But obviously, for the reasons that we mentioned in the talk, there is a lot of risk there. So I don't know. That's a tough one. I would generally say no, they should not, especially the younger campers. But I know that's a tough one because, both of my boys have been counselors at Antiochian Village, and they do, want to keep up relationships, especially with the older campers. So there needs to be a balance. The model policy that we're creating is primarily geared towards parishes. And eventually we would like to create a separate one just for camps, because the camps have very unique issues that are different than parishes. And this is a good example of a unique issue. Alex, do you have any thoughts?
I do. I think what you talked about in terms of the balance is really important. Getting the parents involved, right? If the parents are okay with it and it's no longer part of your program, that's like any other relationship that a person may have with an adult and a minor, right? And we don't want to be overstepping too much. That's that balance piece that you talked about, Ken, that I think is really important here that I don't want to overlook. Involving the parents, and I think that's the example that you cited within this model policy. It's what I use in the policies that I develop. Is we're not suggesting you don't electronically communicate with any minors, but loop in the parents or loop in others as part of that communication. That sort of grooming type behavior that you may hear about either in the media or because you've seen it in complaints or litigation that you've been involved in, involving your parish or involving another entity, is a lot of times where that starts, whether it's Snapchat, Instagram, Facebook, text message, things like that. It's that one-on-one communication that we're concerned about. But if the parents are knowledgeable about it after the program has ended, then it's sort of in their local parentis, right? It's in their sort of jurisdiction as opposed to yours. So looping in the parents to the extent that's important. And I say that maybe as a Serbian Orthodox mom, but also wearing my partner and attorney hat too. So that's my thoughts.
Could I ask a quick follow-up? Because this is all super helpful.
Sure.
Yes.
Obviously, like we can't like police it, right? Like if a camper shares his number, whatever. But like, would it protect us? Would it be beneficial for us as like our camp to have a policy that we communicate with the staff of like, we do not endorse this. We are asking you to be wary of this so that if something did happen, we can say, we told our staff, we trained our staff not to have these communications without parental consent.
I think that's a great idea, especially
Okay.
because you're putting the expectations and notice on your camp counselors, your employees, your staff volunteers, whomever they are. I think that's a great idea. Excellent. Having them sign anything like that, if it's in a handbook, and making sure that they acknowledge it, and then the why. Right? Why are we nervous about this? Because sometimes, we'll have camp counselors who are 21 years old. They don't appreciate sort of maybe the same risk that a 45-year-old would,
Right.
and maybe they do. So thinking through sort of what each person, the why, will resonate with them too, as to why we're instituting it, why it matters. I typically like to make sure I include that in the training. You don't necessarily have to have that in the policy or the expectations document itself, but explaining that will help it resonate more, and then enforcing it. If you find out it is happening and you've set the expectation, um, the hammer better come down on that conduct. And if it doesn't, now you're condoning it. It's as if that expectation document doesn't exist. So be cognizant of that too.
All right. Thank you.
So we have another question. Is there any reason to be concerned if a church facilitates employment? For instance, helping a parishioner, I suppose, help someone with a serious illness in their private home. Anytime, that a church gets involved in facilitating relationships outside of the parish, there is legal risk there because the church is acting and facilitating something that then becomes out of their control. I think there are ways to put up some guardrails, like have some contracts, disclaiming liability, but more important than that, doing some vetting themselves. But that might not always be feasible. I think this is one of those sad situations where in an ideal world, you of course want to facilitate help outside of the parish, but we live in a world where there is risk. And I think every parish is going to have to, this is where we lawyers can come in and be real helpful in balancing that risk versus the benefit, and how do we mitigate that risk as much as possible. There's no right answer. The safe answer is say, no, don't do it. But then, of course, you're missing out on ministry and service opportunities. Question about the 2 adult, 3-person rule. Would non-volunteer parents be welcome and add a further level of protection? Oh, absolutely. The more adults, the better. But what I would say is that even if they're adults who may just help, every once in a while, you really ought to get them to become an official youth worker and do the background check, have them abide by the policies so that they can stand as a backup volunteer. Okay, so the word incidental contact is intentionally vague because there's no way to draw a bright line that covers every single situation. There's always going to be exceptions. I would recommend that a church err on the side of over-inclusiveness in requiring people to do the background checks, to abide by the policies. And so if you want to have backup volunteers to substitute for Sunday school class, for example, those backup volunteers really ought to be treated as youth workers as well.